All right, we're continuing here in the chapter on equal rights. We're going to talk about the judicial tests for equal protection, and we're going to talk about some of the different tiers that have to be looked at for a law to be considered constitutional. And if you remember, in the previous chapter, we looked at footnote 4 of the Caroline Products Supreme Court case. And if you remember that case, it says that the Supreme Court, in the case of the Supreme Court siding with a lot of FDR's programs, they said that, listen, okay, if we're going to expand the general welfare clause to make the government larger, so it's going to get its hands in a lot of areas in the private sector, we are also going to engage in a more searching judicial scrutiny for the rights of minorities, and we're going to scan the first 8 or 9 Bill of Rights and make sure that we're basically siding with or helping minority groups. Because again, remember, it was the same argument that the Anti-Federalists made when they originally looked at the Constitution that was adopted. Is this idea, okay, we realize that you're making the federal government a lot larger. We want a Bill of Rights, okay? Why am I saying all that? Because as we start looking at this concept of strict scrutiny as one of the judicial tests for equal protection, they got that from footnote 4 of Caroline Products, that idea. Okay, so again, just trying to show you kind of the pedigree or the origins of some of this that might help you a little bit, okay? So the first test on slide number 14 is something called the reasonable basis test, okay? So the courts require government only to show that a particular law is reasonable, okay? It does not apply to ethnic or racial distinctions. So what that means is if a law that a legislature at a state government or at the federal government passes, okay, if it's challenged in court, okay, the court is going to defer to the state. The court is going to defer to Congress or the state legislature and realize that the law that they passed was reasonable. Okay, in other words, they're not going to try to overturn that law. The reason being is because the law is considered reasonable. Okay, it's not unreasonable. I'll give you an example of that. The driving age at 16. It is the legislatures within states have a reasonable basis for setting the threshold of the driving age at 16, as opposed to 9. Okay, I mean, I don't know, a 9-year-old driving in a car going 75 miles an hour down a freeway. What's the worst that can happen? Right? Is that there's a reasonable basis for setting that driver's age as far as, maturity and things of that nature. Now, of course, as the father of a son and a daughter, I know for my son, the driver's age, it might have been better for him to have been at maybe 18. Maturity-wise, okay, I don't know, growing up how you were, but there was a lot of tomfoolery that took place with my son behind the wheel and all of his friends. Okay, they would do some bumper car things and all kinds of stuff that I'm thinking, is 16 the best age to drive at? But anyway, be that as it may, okay? The idea is that the burden of proof is on you to prove that the government has discriminate against you. So if a 9-year-old's like, hey, I want to be able to drive, that's not fair. You are violating my 14th Amendment equal protection rights, okay? Any court in the land is going to side with the government creating a driver's age at 16 years old and not giving you at 9 years old a right to drive. So in other words, that your equal protection rights are going to be violated all day long because there's a reasonable basis for this, okay? Where this gets a little muddy, what we've just walked through within this pandemic, okay? Because you were seeing laws passed by, or in this case, executive orders passed by governors, okay? In our case, the state of Michigan, right? You can't gather together, okay? If you're a business, if you're a restaurant, if you're a church, okay? If you're a sports league, Okay? In other words, no gathering together. These are what are called neutral laws of general applicability. They apply to everybody. So no one is discriminated against. Okay? And then, of course, it got kind of interesting because suddenly now certain businesses could operate, but then maybe a church couldn't open or a sports league. In fact, even as I'm recording this, there is still no Major League Baseball. There is still no NBA playoffs, things like that. In other words, certain businesses were perhaps being deemed essential and other businesses being deemed non-essential, okay? Things like that. The reason these were upheld, at least initially, again, there's been lawsuits and things like that that have emerged, but is, again, this assumption of the rationality or the reasonable basis for a law, okay? Another example is the drinking age, okay? States have generally looked at it is there's a reasonable basis for the drinking age at 21. Okay, some states are different, but the thinking is it's just not rational to allow 14-year-olds to drink because, well, what's the worst going to happen, right? Is that same idea, is that the burden of proof is on you to prove that your equal protection rights were violated, not on the state, because again, the assumption within the courts is there is a reasonable basis for having that particular law or executive order or something like that in place, okay? Where governors, as this pandemic is still taking place, but we're kind of reopening as a state and all that good stuff, where executive orders could be challenged successfully in the courts is if the court is, or I'm sorry, if governors are allowing, again, businesses to reopen and maybe, okay, let's just say concerts of groups of 10 to 20,000, you can have concerts, okay? But sports leagues are prohibited from gathering together because they'll attract crowds of that same amount. Or churches can't do it and gather together because they might have if a larger church might have 5 to 10,000 people. That's where an executive order most likely would not survive legal challenge because discrimination is made, okay? Hopefully that kind of makes sense a little bit. But generally speaking, as long as there's a reasonable basis for a particular law or executive order, it will be upheld in court. In particular, if they are neutral laws of general applicability and they apply to everybody. Okay, it's not like 14-year-old girls can drive, but 14-year-old boys can't drive. Okay, in other words, it's 16 years old for everybody. It doesn't matter your race, it doesn't matter your gender or anything like that, okay? If you go to slide number 15, you'll see something called the strict scrutiny test, okay? Now, this is a test where it looks at laws that treat people differently because of their race or their ethnicity. Okay, if a law treats an individual differently because of their race or their ethnicity, it presumes that the law is unconstitutional unless the government can provide a compelling basis for it. Okay, so let's take Plessy versus Ferguson. Okay, the 1896 Supreme Court case that said separate but equal in train cars. Okay. That law or that Supreme Court holding would not survive strict scrutiny test because it's discriminating based on races, okay? So in the case of a law that is subject to strict scrutiny evaluation that deals with discrimination based on race, the burden of proof is now on the government, not on that person to prove constitutionality, okay? Are there laws that separate the races or maybe ethnicities that could be upheld in court and you can discriminate? Okay, is there a reasonable basis for that? An example of that would be in the prison systems, okay? Let's say you've got rioting based on race within a prison. Let's say you have rioting based on ethnicity, okay? Then of course, the prison system would have to, segregate the races just, to protect life and limb, okay? There's a reasonable basis for that. Okay, it's not for all time, but in the case of, prison rioting, you've got to do that to preserve life and limb. That would survive strict scrutiny evaluation, but any other type of discrimination like that would not, okay? And then there's something within strict scrutiny, something called suspect classification, and that is, again, where the Supreme Court would consider race and national origin a suspect class, okay? So if laws begin to discriminate against a suspect class, okay, it's going to presume that there's discrimination and that law is going to be struck down, okay? And so again, if you go to slide number 16, the origins of the strict scrutiny test for race was in footnote 4 of United States versus Caroline Products. That's why I had you read it, and if you so chose, to answer one of the discussion questions, because again, it says in that footnote, whether prejudice against discrete and insular minorities may be a special condition which tends seriously to curtail the operation of those political processes ordinarily to be relied upon to protect minorities, and which may call for a corresponding more searching judicial inquiry. Okay, so again, that's where we get the more searching judicial inquiry is strict scrutiny. Okay, a law that's discriminating against races is going to be challenged and most likely struck down. Okay, there's another test here, and if you go to slide number 17, it's called intermediate scrutiny. These are laws that discriminate based on one's gender are assumed unconstitutional unless the law serves a clearly compelling and justified purpose. Okay, so since 1980, the Supreme Court has tended to strike down nearly all gender-based laws that it reviewed. Okay, case in point was a case, United States versus Virginia, the Virginia Military Institute, okay, which did not allow women to become a part of that institution, okay? The Supreme Court struck down that law and allowed women to get involved and become students at the Virginia Military Academy. Was it controversial? Absolutely, okay? But, and again, you think if you're the first woman to go into this all-male school, okay, awkward, did that take some guts? Yeah. Okay, so courts will, again, there's rational basis, again, the lowest threshold. It assumes constitutionality of laws passed by legislatures, okay? Strict scrutiny, it assumes that if you discriminate based on race, it's unconstitutional unless the state can prove a compelling reason, again, in the case of rioting within a prison. And then there's a mid-level one called intermediate scrutiny, almost as high as strict scrutiny, okay, that deals with women. So I'm going to end there, and we'll move on to slide number 18 next.